Hello everyone, a warm welcome to every viewer. I, Furam Patel, would like to invite you to the introductory session of the legal theory or jurisprudence subject under the law. Jurisprudence in its widest sense does mean the knowledge of the law. But friends, can you really define jurisprudence? Is it so easy to define such a huge philosophical word which carries the different principle, the different philosophy, even scientific views of the law? So friends, the definition of jurisprudence is very important, or rather it is very difficult to define the term jurisprudence. But when we are talking about the jurisprudence, we surely can try and understand the concept as to what constitutes the word jurisprudence. In France, the word jurisprudence means la philosophie du droit, which means the philosophy of the rights. So that means that there are certain general principles which works as under the jurisprudence term. So it again can be stated that jurisprudence is a kind of the science which would help us giving insight about the law. That means jurisprudence as a subject must be covering certain very important and very basic features, or rather principles of the law, which becomes very understand for all of us to understand those concepts if we want to imply and execute the law. So let's get started with the understanding of the jurisprudence, that is juris plus prudence, that is understanding or acknowledgement of the law. There are certain concepts that we shall be discussing in this lecture. The first concept would be the concept of the rights. The another would be the very important concept which is co-relevant, which is the duty. Let's get started by having a look at what are we going to deal in this video. So friends, as you can see on the screen, we shall be discussing the concepts of the rights, the duties, and along with that also of the wrongs, definitions and relations with that regard. Rights and duties correlation, which is very important aspect to understand. Along with that, we shall be discussing the status of the unborn person, minor person, a lunatic person, drunken person, dead, and also a slave. Then we shall be moving on with the understanding of the word title. We shall be discussing this concept with regard to the Salmon's chart, which is very important and widely explained one. After that, we shall be moving on with the concept note on the liability. That would include the concept of the negligence, the kinds of the liability, etc. etc. Along with that, after that, we shall be discussing certain reference cases, FAQs, and then we shall be looking into the reference books that may have been referred. So friends, as I stated, the word jurisprudence is very difficult to define. So as the word rights. What do we mean by rights? So friends, I hope you do have the idea, because in this era, in day-to-day's life, we do use this word a lot of times, that my rights are like this, I have this right, why can I not have this right? You are violating my right. So friends, it becomes very important for all of us to understand what do we mean by rights. As you can see on the screen, even though it is very difficult to define the term rights, certain jurists, of course, have given certain definitions, or rather a concept in side notes for the concept of the rights. According to Salmon, an interest which is recognized and protected by the rules of the legal justice, that is what you can call as the rights. Austin, on the other hand, has stated that a party has a right when another or others are bound or obliged by the law to do or forbear towards or in regards of him. That means, my friends, Austin is giving the definition of the right while implying others to fulfill their own duties. And the jurist Salmon has stated that when the rights word has been used, it is there along with the interest which is recognized and protected by the law. So both of the jurists are saying that the right has to be lawful, along with that it has to be protected, and certain duty of the other party must be bound along with the same. Along with different jurists, even our courts have tried to define, or rather get insight of the concept of the rights. As you can see on the screen, in the state of Rajasthan versus Union of India, the court has tried by stating that in a strict sense, legal rights are correlatives of the legal duties and are defined as interests which the law protects by imposing corresponding duties on the others. Again, my friends, this is very much similar to the concept of the Austin's right, of Austin's definition of the rights. Now, moving on, but in a general sense, the word right is used to mean an immunity from the legal power of another. Immunity is exemption from the power of another in the same way as the liberty is an exception from the right of another. So that means, my friends, that the court is also trying to discuss the word power, the word immunity, the word exemption, the word right, the word liberty all together while describing the concept of the rights. So that would make me go to the definition of the Roscoe Pound. Roscoe Pound has defined the rights by giving an exhaustive meaning and providing 5 different ingredients which are considered to be the main ingredient to constitute the concept, or rather the term right. The first is that interest. Now this interest has to be recognized by the law and it has to be secured. It must be secured rather. The second ingredient is that a recognized claim or interest which forbears others for the protection of the interest. The third one talks about the power that we saw in the previous case, that the word power was used. So how power is relevant with the concept of the rights? Roscoe Pound is stating that power to create and recognize rights and duties defined. So to create the rights, even to recognize them and even to define the concept which is correlevant with the rights, that is duty, power becomes very important aspect. The next one is capacity to create the conditions of the general or specific non-interference with natural faculties of the interest. That means one person's interest in one thing is must to create the right. The fifth and the last one is in accordance with the justice and give effect to the moral rights. So that means, my friends, that Roscoe Pound is also trying to recognize the concept of the moral rights along with giving the exhaustive meaning of the term right. So these are the 5 main ingredients as discussed by Roscoe Pound. Now, after analyzing all these different definitions of the rights by Austin, by Salmond, even by the court of law in one of the cases as we saw, and the Roscoe Pound's definition, we can have certain definite results which would define the term right. So these results may be stated as you can see on the screen. The first one is that rights distinguished from the might. Imperfect right, rights enforceable on its own, and the rights and the duties correlations. Now this dissection is a result of the Holland's definition, which emphasizes on the importance of the power, which is talking about the rights. When we are studying the first line, right, the first result, that is rights distinguished from the might, it becomes very important for all of us to understand that how this differentiation can be made. So rights, what do you mean by rights and what is meant by might? Now this is as a result of the Holland's definition, we shall discuss in regard to the Holland's concept. So rights here, that would mean that the rights here would mean that power, or rather capacity of one individual of obliging others. Now here the others is not somebody else, or it is rather the third party who is trying to oblige and not by one's own strength. Whereas the word might mean obliging others to do certain act by one own strength. So that distinguishing if you are making, then we can understand the concept of the rights in a better manner. Then comes the next one, which is imperfect rights. Now friends, this means that no right in its own nature can be called as a perfect right. Why? Because no right is perfect. As we have studied the law and as we are also studying the law, it becomes very important for all of us to understand that the definitions even given by the jurists, they are also stating that one person's rights give a birth to another person's obligations, or rather duties. So that means that rights and duties are correlevant with each other. We shall be discussing this point later on in detail, of course. The next point is right enforceable by its owner. This means, my friend, that Holland is trying to define that one individual must be able to go to the court of law when that person's certain rights are violated. So he shall be having the right of enforceability with regard to the same thing. And the next is rights and duties correlation. So friends, here the jurist Holland is trying to conceptualize that when one person is having a right of one particular thing, that at the same time, on the other hand, there has to be, or rather there must be, a corresponding duty of any other person that is falling. If the rights is there along with the duties in a corresponding way, then only the concept of the rights can be justified, and rather it can be understood in its true sense. Along with these definitions, the definition, or rather the interpretation by Hoffeld, also becomes very important to understand when we are talking about the concept of the rights. Now my friends, Hoffeld is trying to interpret the term rights by dividing it into these four terms. Now what are these four terms? The first term is immunity, the second is rights, the third is privilege, and the fourth is power. So Hoffeld is trying to state that if immunity is there, which along with the rights is having privilege and the power to protect all these and oblige other persons to have their own duty, then and then only the true sense of the concept of the rights can be interpreted. So Hoffeld is stating that immunity has to be there of an individual while protection of their own rights. Privilege must be given to that person because rights has to be utilized against every individual in the society. Along with that, the power must be there with that individual to protect one's own right against any other individual in the society. And as we stated, the rights is no longer there when the duties are not there. So when one person wants to impose somebody's or an individual's rights, they must be able to impose the other person's duty. So Hoffeld is trying to interpret the concept of the rights by dividing it into these four terms. Now friend, if you understand that the term privilege is having a wider implications, or rather a wider meaning in terms of the law when we are talking about the rights. So this comes to an end about the first session of the introduction, which only discusses the concept and the definition of the rights in very detail, given by different jurists and even court of law, which is very important. So friends, in the next lecture, we shall be discussing the kinds of the rights and the further implications, or rather the further concepts that can be defined or discussed under this concept of the rights and the duties. Till then, keep studying. Take care.